I'm Navya Shekhar. I'm Head of Employment and also a Director at Truth Legal. And today we're going to talk about 5 essential documents that you need as an employer. Some of these documents you're legally obliged to have them as an employer, and some it is good practice to have. It can be really beneficial in terms of managing any potential claims that may arise from your employees. So the first document that we will talk about today is written particulars of employment. Now, you're legally obliged to provide written particulars of employment to your employees and workers pretty much on the day they start. So I'll go through what these documents, what this document relates to, but essentially it's called either Section 1 statement or written particulars of employment. And the law requires you to include certain information within this document in order for you to be complying with the legal obligation. So, as I said, it's a day one right that your employees have and workers have. You need to provide this to them on day one. But some of the element of this information can be provided to them in installments. So some aspect you have to provide on day one, and some can be provided to them within 2 months, essentially, of the start date. Written particulars of employment is not a contract. It is different from a contract, but I will reference later on why I would suggest that you should provide a contract of employment which incorporates elements required to be, which you're legally obliged to provide to your employees and workers. But we'll come to that in a minute. The written particulars of employment also needs to include some non-contractual elements. For example, disciplinary procedure, grievance procedure, and I'll go through some of the examples with you in the next slide. This document should be, reasonably accessible to your employees and workers. So it should be provided in a format or in a manner which they can easily access. So I've split this, the information that you're required to provide to your employees or workers into sections. So from the start of employment, you have to provide the following information within written particulars of employment, which is names, dates, what their remuneration, what their salary or will be, how many hours they'll be working, what is their holiday entitlement, how much notice they need to provide, and you need to provide to them if the employment was to be terminated, what's their job title, and a brief description of the job would be a good thing to include. Period of employment, so is it fixed term, permanent, how does that work? Probationary period, if there is any applicable, then you need to put the length of the probationary period. If it isn't applicable, then you simply need to say no probationary period applies in your case. So that information needs to be provided on day one. Of course, you can provide the other information as well on day one, but if you've not provided it on day one, the other information, which is set out in the other column, which relates to place of work, whether it's within UK or outside of UK, how would that work for them? Are they required to work work outside of UK or not? What kind of training, if any, will be provided? If you're not providing any training, then we just need to say you will not be provided with any training. What benefits they're entitled to within when they're employed by you? What is the reporting procedure for sickness and incapacity, and what, if any, pay would be given to them? So that needs to be included. Details of any other paid leave, pension, for example, can have compassionate leave or maternity leave, those sort of paid leaves that could be that you have to give information about. Pension and pension, supply that was needed. So that needs to be in. But you need to provide the pension scheme, pension details to your employees. Are there any collective agreements that exist? So you could have, some organizations may have recognized unions, and there could be collective agreements that have been entered by with the unions, and that would apply to the individual. So those things need to be looked at and considered. Of course, you've also got to provide disciplinary rules and procedures, and same as grievance procedure and grievance appeal process as well. So these are some of the examples of the information that needs to be incorporated within your written particulars of employment. What happens if you don't provide these things? So potentially, if you don't provide the information when you're legally obliged to, your employee can take you to the tribunal for failure to provide written particulars of employment. A tribunal, in the absence of this information being provided, the tribunal maybe could draw up or conclude what the terms would be, or what should have been the terms within the written particulars of employment. So it's basically not within your hands then to control what is being determined by the tribunal, and then you're bound by it. Also, there may be the tribunal may decide to award to give a financial sanction, which is up to 2 weeks of their wages as compensation to the employee. And that's generally speaking more in the situation where an employee has brought other cases alongside with this claim in relation to failure to provide written particulars of employment. Now, this is an alternative to contract of employment. My suggestion, or rather, my suggestion would be that a contract of employment is provided as an alternative to written particulars of employment. And the reason I say that is because a contract of employment will allow you to incorporate a lot of other aspects that will protect the business, rather than just having written terms within what we call written particulars of employment. So for example, all businesses have confidential information, and they want to protect themselves from any employee disclosing such confidential information to third party. Now, a contract of employment can include these and can ensure that the business is protected from that point. Also, since COVID, a lot of organizations have hybrid working or working from home policy. There would be a lot of company property that is being given to all other to employees, and it protects the company in the sense that if the contract includes contractual terms which requires the employer or makes the employees obligated to return these company property upon termination of their employment, it protects the employer's assets. So it helps that way. Expenses, again, it sets out how an employee can claim expenses rather than having nothing set out in your written particulars of employment. So it's a good thing to have a contract which can set out things like these. In addition, one of the things that I find that employers face problems with is excessive sickness absence. Now, if you've got a contract of employment, you can include a clause within that which allows the employer to make referral to occupational health to get a better understanding of the health issues of an employee and see how best it can be rectified from business perspective, but also from employees' point of view. Also, sometimes employment may, when an employee resigns or their employment is terminated, it may not be in a situation which is very amicable, and an employer may not want them to work through their notice. So having a provision for garden leave gives that extra right to the employer to ensure that during the notice period, an employee, although will remain employed by the employer, but they will not be required to do work unless the employer wants. So the right that an employee has to be given work can be set aside if a clause is included in the contract of employment. So that's helpful from an employer's perspective. And one of the other things that is quite common that employers would like to have included is restrictive covenants, which is essentially post-termination restrictions that an employer may want to implement for employees. They may have access to sensitive information, business information, and you may want to limit them from being able to use that in competition with your business. So, plus you may also limit, in certain circumstances, you can limit them from going and working for somebody else who's in direct competition with your business within the, a defined area, or it has to be reasonable. It has to be something that you can show is in the best interest of the business, but there is scope for you to have restrictions, post-termination restrictions within your contract of employment, which again is beneficial for the business. So from that point of view, it is essential to have, or it would be preferable to have a contract of employment rather than a written particulars of employment. So the next document that I would say that employers should have is, and you're again legally obligated to have, is disciplinary rules and procedures. Now, most businesses at some point will have a situation where they're having to deal with a disciplinary situation and carry out investigation, and if the investigation has a case to answer, then it would lead to disciplinary sanction. So you should have, and the law requires you to have disciplinary rules and procedures in place. So that this is another document that needs to be there. It is beneficial because it helps it's not only because it's legally, you're legally obliged to have it, but it is also beneficial because it sets out the process that you should follow. And it's almost like a guide that you can utilize to address difficult situations. So, but the thing that you have to note here, as opposed to a written particular of statement, employment statement, disciplinary rules are only documents that should only be provided to employees, not to your workers, not to your consultants or self-employed freelance individuals. It is limited to be provided. It is limited for employees. It will only apply to employees. And the benefits of having this is that you can tailor your process of disciplinary process to your organization rather than having to rely solely on the very basic documents that is available with ACAS. So whilst you can utilize ACAS document, if you've got your own disciplinary rules and procedures, you can tailor it to fit the needs of your business and how you want to approach a situation rather than having it a generic document. It also will, you can utilize a document, disciplinary document, rules and procedures to set out the culture of your organization, to reflect what is acceptable and what is not acceptable conduct within your organization. It can also help set standards and expectations of your employees. So it is really beneficial for both employer and employee in that respect. And it also assists with statutory defense for harassment claims. Now, quite often you might have people who would, employees who are bringing claim about being, harassed at workplace. They might tender their resignation and claim constructive dismissal. And as part of that, they will be saying, well, I've been subjected to harassment. I had raised complaints about this and nothing was done. So if they were to do something on those lines, if you have a disciplinary procedure, rules and procedure in place, you can be saying to them, well, we have complied with these when you'd made a complaint. Or alternatively, if they have been dismissed and they're saying, well, I've been subjected to harassment and no proper procedure has been followed, if you have a disciplinary procedure in place, you will be able to demonstrate to the tribunal that actually this is incorrect. We have followed this procedure, which has been, which is set out in our documents, and the claims made by our employee, ex-employee, is not correct. So that's how you would be approaching that aspect. What I would also say is that the policy should have two separate sections. One is for minor breaches and one is for gross misconduct. And I'll explain why I suggest you should have two different, procedures for it, because it is of assistance. Sorry. So if you've got two different sets, you can differentiate between what, as an organization, you consider as misconduct, but it is not serious enough that could potentially lead to dismissal. So, for example, minor breaches would be where people have poor timekeeping, but it is not, it is not acceptable to be not at work on time. But you don't want to be necessarily thinking in terms of terminating somebody's employment for a first offence of poor timekeeping or an initial few attempts. Damage to or unauthorized use of property. So it can be an accidental damage. They might have been careless, and that is a breach of your policy or your contract, but it is not significant enough to allow you to terminate somebody's employment. So these would fall under minor breaches, for example, failure to follow instructions, unauthorized absence from work, excessive use of telephones for personal calls and messages. So these generally would be examples of what will be a minor breach. In terms of breaches that can be dealt with as gross misconduct, if somebody is subjecting another individual to discriminatory conduct, or is harassing them, or they're being subjected to victimization because they raise certain concerns and then they are being hounded for that, those sort of issues will be considered as gross misconduct. If somebody's had conviction of a criminal offence, then again, in a lot of situations, that would amount to gross misconduct. Serious neglect of duties, theft, fraud, violence, disclosing false information, and refusal to follow reasonable management instructions. Now, you can see there's slight difference. We've got one in minor breaches, which is failure to follow instructions, and we've got one which is refusal to follow reasonable management instruction. And the difference really is, one is something which somebody is not done, but it is not deliberate. Whereas refusal to follow reasonable management instruction is a deliberate act, and that itself can amount to gross misconduct, and an employee can be dismissed for that reason. So moving on from there, with regard to disciplinary rules and procedures, what should the rules and procedures contain? If you got taking, if an employee is going to be subjected to a disciplinary process, then, or even for that matter, if somebody's raised a grievance, then the process to be followed is, initial stage is to carry out an investigation into the allegations or the concerns raised. You should be notifying your employee of the concern. So if a complaint is raised against an employee or an allegation is made against an employee, that employee should be notified of such a complaint. They should then be invited to investigation meetings. And if following the investigation, you conclude that there is a case to answer, then these individuals should be called, or this individual should be called to a disciplinary meeting. At this disciplinary meeting, that this individual should be given the right to be accompanied by either a work colleague or a trade union representative. Now, there is no legal entitlement to be accompanied by anyone else other than these two. However, if requested, an employer can allow somebody else if it doesn't cause any issues. But the legal obligation is limited to allowing a work colleague or a union representative. There is no right to be accompanied for an investigation meeting. However, I would say it's good practice to allow somebody to be accompanied if such a request is made. Once you've had the disciplinary meeting and and there is no further investigation required, then a decision needs to be provided to the individual, and they should be given the right to appeal against such decision. Once they've appealed against the decision, then they should be invited to an appeal meeting, and again, they should have the right to be accompanied at this meeting. Following the appeal meeting, you can then give the appeal decision. Again, whether it's a disciplinary meeting, grievance meeting, or appeal meeting, a decision can be given at the meeting, but my recommendation would be to take things away, consider what has been said, and then provide a decision, not immediately. Otherwise, it would usually come across as being predetermined decision. So grievance procedure is the third document that an employer should have should provide to their employees. Again, it makes sure that people know if they have any concerns, how to raise them and where to raise them, with whom. And it also gives the employer the tool to ensure that they're dealing with employee concerns in an effective way. The initial process, what I would always recommend with any grievance procedure would be to have a setup, which is an informal setup, where you can have an informal meeting to see whether those concerns can be addressed before it escalates to a formal process. If the matter cannot be addressed at an informal stage and the employee wants to initiate formal grievance process, then of course that should be, the employer should follow the formal grievance process, should carry out an investigation into the concerns raised, and again, should have a grievance meeting. Now, at the grievance meeting, just like in a disciplinary procedure, at the grievance meeting, the employee has a right to be accompanied by a work colleague or by a trade union representative. At the investigation stage, again, they don't have a right to be accompanied. However, there is nothing stopping an employer from allowing them to be accompanied for such meetings. Once you've concluded the investigation, have had the grievance meeting, an outcome can be provided. Again, this outcome can be provided at the hearing itself, grievance hearing, grievance meeting itself, or you can take all the information, go away, give it some time to consider, and provide the outcome. It can be provided by reconvening the meeting or by providing a letter to the employee with the set outcome. It is always best to provide the reasons as to why the reasons for the decision. So that's in terms of the actual outcome of the grievance. With the outcome of the grievance meeting, the employee should be given the right of appeal, and an appeal meeting should be conducted in similar manner as a disciplinary meeting. They will again have the right to be accompanied at this meeting, and the same process would follow, where you consider the information provided, the reasons for appeal, and then provide your outcome. The whole process should be done ideally within a reasonable time and without unreasonable delay. Sometimes the complexity of the issue can mean that you're having to take a longer period. However, it should be justified. It should not be an unreasonable delay. It should be something that you can justify why it has taken you time. So the fourth document I would say that you should have is equal opportunities and harassment policies. Now, this is not a legal requirement, but in my view, this is a very important document that the employer should have, and it is best practice to have it, and it would assist in maintaining good standard within the workplace and managing employee behavior. It would assist in having fair workplace and will help with staff retention. It will also help with ensuring that employees understand what is being required of them in terms of treating individuals equally. If they're not complying with or they're not treating others equally, they may well be in breach of Equality Act and discrimination law. So that is where it is. That is why it is important to have equal opportunities and harassment policies in place to ensure that you've got a statutory defense as well to say we do not encourage such behavior. We have got policies and procedures set in place advising our employees what they should be doing and what they shouldn't be doing in certain circumstances. It also assists with managing any bullying culture that the workplace may have or may develop. So when looking at equal opportunities and harassment policies, the things that you would be looking at, which is that needs to be sort of accommodated or included within your policy, is in relation to discrimination and in relation to the protected characteristics that are set out under Equality Act 2010. And the protected characteristics are really age. So somebody can feel discriminated against because either they're too old or they're too young in an environment. So somebody's constantly saying, oh, you're too old for this job, you can't do it properly because of your age. That is discriminatory conduct, and it needs to be dealt with appropriately. Disability. This is, generally speaking, one of the biggest areas where employers tend to get have claims being brought against them, and that tends to be disability and failure to make reasonable adjustments. So if you've got equal opportunities and harassment policies in place, to a degree, such claims can be addressed. Gender reassignment, marriage and civil partnership, pregnancy and maternity. Another one where frequently claims are being brought against employers because things haven't been managed appropriately in those circumstances. And again, having a policy in place will assist with employees knowing how to deal with a certain particular situation. Race, religion or belief, and gender, sex and sexual orientation. All of these are the characteristics set out, protected characteristics that have been set out in under Equality Act 2010. And having the equal opportunities policy and harassment policies would assist to manage any repercussions that arise as a result of any claims for discrimination brought by individuals who may be impacted by or who may fall under these protected characteristics. So the question then is, what are equal opportunities? Equal opportunities avoid direct discrimination claims. So you know, as an employer, you will not treat anyone differently because of their protected characteristics, whether that's age, gender, race, religion, religious belief, whatever it may be. So direct discrimination, the definition for it in Equality Act is person A discriminates against person B if, because of a protected characteristic, A treats B less favorably than A treats or would treat others. And the example would be, say, for example, if you're not offering a job. Let's say somebody who's pregnant applies for a job, and as an employer, you choose to not give that job to the individual because they are pregnant and are likely to go on maternity leave shortly. And that may be a reason, but that is discriminatory if they are not offered a job for that reason. And the other example could be things like if people are not being promoted or they're not being paid, awarded a pay rise, or they're not being provided a training because of their protected characteristic. One of the things that a claim can be brought under Equality Act is for, say, a man is being paid more than a female because she is female, even though they're doing the same job. Now that is discriminatory. And if the decision to pay them differently is based on their gender, then that's discrimination. So the policies in place, equal opportunities policies in place, would ensure that these acts are avoided, and you have a statutory defence to say, well, you know, we are an equal opportunity employer, and we don't discriminate against other people with protected characteristics. The other aspect is harassment, and what is the legal definition of harassment, and what is it in connection with, and is it in connection with a protected characteristic? So Equality Act has a section on harassment and defines what is harassment, and which is set out in the slide here. So person A harasses person B if A engages in unwanted conduct related to a protected characteristic, and the conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. One of the example could be, for this can be, where a long time back I had actually seen, as part of doing my job, we had seen a photograph that was presented to us, and this was a few years back, and where there was a group of people standing around a person who was digging a hole, and they had labeled the individual in the hole as being a Polish man and the rest being white British. Now that is degrading, violating, the Polish man's dignity, and it is creating a intimidating, hostile, degrading environment. And that individual wanted to pursue a claim against his employer. It wasn't the employer's conduct, it was some individual within their employee who had done this, but ultimately the employer would have been liable for it. So if having a equal opportunities and harassment policies in place sets and would put measures in place to ensure that the employees are aware of what things they can do and what things they can't do. If despite that procedure being in place, an employee acts contrary to the equal opportunities and harassment policies, you could take them through the disciplinary process and potentially could be dismissed on grounds of gross misconduct. That's where it then links up to your disciplinary procedures. And then again, you can also have section within your equal opportunities policy defining what is perceived and associated discrimination. Sometimes people may perceive another having a particular illness or disability, which in fact they may not have, but in the other person's mind, they have a particular condition and they may treat them differently because of that reason. And that's what perceived and associative discriminatory conduct can be, because if you've been treated differently because of a third person's perception, then that could amount to perceived and associative discrimination. Again, not acceptable within law. As I said earlier, employers are responsible for acts of their employees, and the defense that an employer can have to protect themselves in a situation where an employee of theirs has acted in breach of law is that they have taken all reasonable steps to prevent employees from doing the discriminatory acts. The steps can be, that one, you've got policies and right policies in place. You update your policies regularly and they're circulated regularly. Employees are provided regular training. So perhaps when they start, they're taken through the equal opportunities and harassment policy at the start of their employment, and a refresher is perhaps done every year, maybe. So that would help with keeping on top of or demonstrating to a tribunal that we've done what we can. We've done we've taken all reasonable steps, and we should not be held responsible for an individual's act who has acted contrary to our policies and procedures. And then, as I said before, if one of your employees is treating some other employee in a discriminatory way, or has done some a conduct which can be classed as gross misconduct, you can take them through the disciplinary procedure and their employment can be terminated. Again, that's showing that you do not tolerate, there's a zero tolerance policy that the employer has. And taking disciplinary action will demonstrate that. So all of these things will demonstrate a defense for you. So having the equal opportunities policy, which links to disciplinary if people are breaching this policy, will assist in showing to a tribunal that you've done what you can do as an employer. The final document that I would say you should have in place is a privacy notice. Now, as an employer, you are a data controller and you have control over, and you'll be handling your employees, workers and consultants, etc., their data. So the law requires you to handle data in a particular way. And because you're a data controller, a third party whose data you are controlling can make subject access request, which can be very tedious to deal with. But you need to be aware of how you handle the data that you're storing as a data controller, which is why you should ensure that you've got a privacy notice in place, which is provided to employees, workers, consultants. The privacy policy should set out how you will use and collect process the personal information that is being provided by your employees, and the legal basis for doing so. So one of the things would be payroll. For payroll purposes, you've got to have their bank details, you've got to have their address and, and there might be other documents that you've got, say, for reporting purposes, or if there's an incident at work, you need to know their next of kin details, their, phone numbers, etc. So you're handling all of that, and you're going to be explaining to your employees why you need this information and how you will handle that information, whether you'll be, so you will be restricted from how you handle it under law. So lengthy document, but a privacy notice will generally be a lengthy document, but usually is a standard kind of document, and you should give it out with contract of employment. It will probably be standard document for every employee. There might be slight variations depending on if they're a worker or a consultant, and how, and therefore your obligations might be slightly different, but that will essentially be a very standard document for everyone across the board. In terms of the privacy policy, it may also be privacy notice. It may also be a good idea to consider and include how long you're going to retain documents for, and the time period would, to a degree, will also be dictated by what is required by law to be retained for how long. So different documents can be retained for different time period. You need to consider if the document has more than one use. For example, expired warnings used for redundancy selection processes. So individuals' personnel file, which would include their performance and disciplinary. As part of disciplinary, somebody may have been given a written warning, say, for example, for 12 months, but that warning may have expired. The relevance of that from a disciplinary point of view no longer exists, but the retention of that information is relevant in case you, say, for example, you're going through a redundancy procedure and you're setting out criteria, and one of the criteria is disciplinary. Have you had disciplinary? You might get points based on if you've had disciplinary in the past or not. And in that context, retention of that information for a longer period is justified. So it just needs to be in what is the purpose of it, and how long it can be kept. So that's essentially privacy notice. These are, in a nutshell, the 5 essential documents that I would say is contract of employment. I would always have an initial offer letter followed with a contract of employment that is being given to an individual. Grievance and disciplinary procedures and policies, equal opportunities policy and harassment policy, and privacy notice. These are the 5 essential documents that, in my view, all employers should have, and some of this is anyway legally, you're legally obligated to keep and provide to your employees.